Hello, and thank you for listening to this podcast. My name is Karen Killalea. I'm a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. Before I dive into today's subject, just some housekeeping to cover off as usual. If you are listening in from your usual podcast app, you'll find the resource documents that we mentioned throughout this episode and speaker information in the description. If you've clicked on the media player link, which we sent to you by email, then you can find this information in the notes section. As always, this podcast contains a general overview in relation to handling leave requests. It does not constitute legal advice, and if you have a specific situation or question, please do reach out for tailored legal advice. Last but not least, don't forget to subscribe to the Maples Irish Employment Law podcast on Apple, Spotify, or Google Podcasts. So I'm joined today by Ciara Ní Longaigh, an associate on the employment team here at Maples, and we are going to take a look at how to handle leave requests. So this is the final episode in our How to Handle series, and it's timely. A lot of leave requests coming in at this time of year. Okay, so let's kick off with maternity leave. Ciara, could you provide us with an overview of the key entitlements which an employer should keep in mind with respect to maternity leave in Ireland?
Yes, absolutely. So as many listeners will know, an employee is entitled to 26 weeks of ordinary maternity leave with the option to take an additional 16 weeks leave. Assuming the employee has the required PRSI contributions, which is actually quite a low threshold, they are entitled to state maternity benefit. However, that being said, many employers do choose to top up the state payment. While it's not a legislative requirement, many employers do choose to top up that payment. The additional 16-week leave typically isn't paid. However, an employee may wish to tie their unused annual leave and parents' leave together with their maternity leave entitlements, and we'll discuss those a little bit later on. In terms of timing, an employee must take at least 2 weeks maternity leave before they're due to give birth, and at least 4 weeks leave after the baby is born. In addition, it is important to note that annual leave and public holiday entitlements continue to accrue during maternity leave. Just to add for our listeners, it's also worth flagging health and safety leave, where a risk assessment identifies pregnancy-related risks that cannot be removed from the workplace. Modified duties or transfer to safe work may be explored. If this is not feasible, health and safety leave can kick in, and the first 21 days of that leave are paid by the employer. In addition, employees who are breastfeeding also have a statutory right to paid time off each day, up to 60 minutes, to breastfeed or express, which can be taken in one block or split by agreement with the employer. Recent legislative amendments also provide that maternity leave can now be postponed in exceptional circumstances, such as serious health complications of the mother or the hospitalisation of the child. The deferral can be significant, can be for up to 52 weeks, so long as the statutory conditions are met.
Thanks, Ciara. And I might just take this opportunity to recap on a couple of important legislative protections for employees who are pregnant or those who've recently given birth or who are breastfeeding. They have very robust legal protections under Irish law. So, for example, a dismissal connected with pregnancy or maternity leave is prohibited. Any notice of termination which is issued during maternity leave or due to take effect during a maternity leave period is invalid. Also good to remember that an employee who is on maternity leave has a right to return to the same role or a suitable equivalent role unless there is a genuine redundancy situation. So, Ciara, do you want to just talk us through adoptive leave? I think that framework really broadly mirrors what you've just discussed, but
Yes.
let us know.
Yes, it does. So an employee who's entitled to adoptive leave can avail of 24 weeks ordinary adoptive leave. And as with maternity leave, there is a state benefit which is available for eligible employees. Again, some employers elect to top up that state benefit to ensure that an employee receives their full salary for some or all of this time. Employees may also elect to take an additional 16 weeks of adoptive leave, and there is no state benefit available in respect of additional leave. The key question we often get asked is who qualifies for this type of leave, and the definition encompasses a sole adopter as well as married couples, civil partners and cohabiting couples. Where a couple jointly adopts, they can choose which member can take the adoptive leave under the legislation.
Okay, that's great. Thanks, Ciara. Let's talk about the other leave. So there's paternity leave, there's parental leave, there's parents' leave. Tell us about paternity leave.
Yes, well, this form of leave is available to the other parent who is not availing of maternity leave, and it usually is taken around the birth or placement for adoption. Eligible employees are entitled to 2 weeks paternity leave. In relation to the entitlement to paternity leave, the father of the child, the partner, so the spouse, civil partner, or cohabitant of the mother of the child, or the parent of a donor conceived child are all entitled to take paternity leave. Paternity leave is governed by the Paternity Leave Benefit Act 2016, which we will put in the show notes. And a state benefit, again, is available for employees during this type of leave.
Perfect. Okay. And parental leave. Tell us about parental leave, different and distinct.
Yes, and parental leave and parents' leave are often confused. So they're two separate forms of leave. Parental leave is currently 26 weeks per child and it's unpaid. It must be taken before a child's 12th birthday or 16th birthday if a child has a disability. Typically, an employee must have been employed for 12 months to avail of parental leave, although pro rata access can be available for shorter service. I must also mention that annual leave and public holidays accrue during parental leave, which again affects leave balances and holiday planning.
Yes, absolutely. And I think historically the uptake of parental leave in Ireland has been low, which is not a surprise really, given that it is an unpaid period of leave. With the increase to 26 weeks parental leave per child, it certainly has made it more meaningful for families where they can afford to use some or all of it. And probably just good to note that employees who had previously exhausted the 18 weeks parental leave, they now have that ability to take the extra 8 weeks. And that obviously came into force when the law was amended, and it applies up to the relevant age cutoff. So will you tell us a little bit about parents' leave, the third type?
Yes, no problem. So parents' leave is shorter. Each parent is entitled to 9 weeks leave to be taken out within the first 2 years after the birth of a child or the adoptive placement. Once again, state benefit may be available, and some employers do choose to top this payment up, but again, it is not required under legislation. The 2026 budget provided for an increase of €10 to bring the state benefit up to €299 per week with effect from 2026. From an operational standpoint, parents' leave is designed to be more accessible financially, albeit for a shorter duration than unpaid parental leave. An employee can take this form of leave in separate weeks or all at once.
Ciara, let's touch briefly on some adjacent entitlements. Some of the leaves that we would see quite frequently in practice and that we would receive questions on. Tell us a little bit about carers leave, force majeure leave, and leave for medical care purposes.
Sure. So carers leave can run for 104 weeks. It's unpaid from an employer perspective, although a state carers allowance may be available. And there's no single care leave payment. It depends on the scheme applicable to the employee. It's available to employees in a caring capacity, and there are specific requirements under the legislation which set out which employees would be entitled to avail of this type of leave. Another type of leave which comes up from time to time is force majeure leave. It's a very short form of leave. It's an employee is entitled to 3 days per year or 5 days in a 3-year period. It is a paid form of leave, and it's only provided where an employee's immediate presence is indispensable due to injury or illness of a close relative. Finally, a relatively new form of leave, employees can also take leave for medical care purposes. So employees can take up to 5 days unpaid leave per year for serious medical care needs of a child or relevant person, which is distinct from force majeure leave, which is paid for an urgent family crisis. An employee can also avail of domestic violence leave, up to 5 paid days in a 12-month period. This is also a relatively new form of leave, and it is specifically focused on supporting employees in crisis with relocation, medical assistance, counselling, court orders, or Garda assistance.
Thanks, Ciara. Okay, so let's turn to annual leave, so statutory annual leave. And in Ireland, full-time employees are entitled to a minimum of 20 days paid annual statutory leave. So as you've already quite rightly reminded us of, statutory annual leave continues to accrue during certain forms of statutory leave, such as the maternity leave, adoptive leave, paternity leave, and parental leave. So is there anything else, Ciara, really that employers in Ireland should be aware of coming up to the busy festive season as it relates to annual leave? So, for example, I'm kind of thinking of everybody clamouring to take the time off between, say, Christmas Eve and New Year's. Just talk us through that.
Yes, it's a good question, as the festive period is very much on our doorstep. And at this time, it's very common, as you say, for competing leave requests to arise. It's a time when children are off from school and everybody wants to enjoy the festivities. However, it's also the busiest period of the year for many companies. From a legislative perspective, the times at which annual leave is granted to an employee can be determined by an employer, having regard to work requirements and subject to the employer taking into account the need for the employee to reconcile work and any family responsibilities, the opportunities for rest and recreation available to the employee, and whether the employer has consulted with the employee or trade union, if applicable, no later than 1 month before the day before the annual leave is due to commence. It's worth noting also that generally there are 3 public holidays over the festive period, which are Christmas Day, Stephen's Day, and New Year's Day, the 1st of January, which the majority of companies would close for. And if an employee is required to work those days, they should be paid in lieu of these days. It should be noted that some companies opt to close their office for the period of Christmas to New Year's. And in some cases, an employee's contract of employment may provide that employees are required to utilise some of their annual leave entitlement in respect of same. It is common for some employers to require employees to save 2 to 3 annual leave days for the Christmas period. So to cover Christmas Eve, the 27th, the 28th, depending on the days that they fall on. Again, this is company specific and down to the management committee of the company. So an employer has the power to implement mandatory periods of annual leave to accommodate shutdowns, but this should be agreed in advance as far as possible with employees. It's advisable to have an annual leave policy, and that should be clearly communicated to all employees, such as not making any arrangements before annual leave has been granted. If there are conflicting requests, it's advisable to have a transparent process which can be used to determine the outcome of leave requests, which an employer is not inclined to grant. So some companies use a first in request, first served policy.
Thanks, Ciara. And a slight digression from the theme of leave and how to handle leave requests, just as you mentioned, the Christmas period and the various social events that take place. I might just very, very briefly mention sort of 4 or 5 tips that I think you would agree, Ciara, probably are worth reminding employers of in Ireland in advance of that season, just from a pure Irish employment law perspective. So I think the first tip would be it's really good practice for employers to send, just a friendly reminder to all staff before a Christmas party and the other sort of various, team events that happen at this time of year, just reminding everyone of the company policies governing appropriate behavior at work and work-related events. So even though these social events are outside of normal working hours, they are work events, they are very likely connected to the workplace, and it is therefore appropriate just to remind employees of their obligations. I think the second point that we would probably make is when communicating those reminders to employees, it is certainly, we are seeing it's more commonplace these days for employers to go that sort of step further and just remind employees to be responsible in terms of alcohol consumption, and just to reiterate a strong message of, sort of zero tolerance for any unlawful substances. So look, certainly I don't think employers would be outliers if they're providing communications of that nature. Certainly that is what we are seeing in the market. Another piece that we will commonly see in employer communications is just reminding employees to plan their transport home, particularly if the location of the social event is perhaps off the public transport routes or hubs, and just giving the links and whatever they can to employees to help them to plan their route home. I think one piece also that we are very much in favour of is just ensuring that the dignity at work policy, which an employer has, is not just sitting in a drawer somewhere, that it's up, it's visible, and really ideally employers in Ireland should be providing training, interactive training on their dignity at work policy on an annual basis. So it doesn't necessarily have to be done at this busy time of year, but we certainly would recommend that you schedule that at some point in Q1 of 2026 if it hasn't already been done. All right, so sick leave. Ciara, can you walk through some of the key points that employers in Ireland need to keep in mind in relation to handling sick leave requests?
Yes, absolutely. So while we're not diving into the detailed statutory sick pay mechanisms today, there are a few points which we thought would be helpful to highlight. So, as many listeners will know, the Sick Leave Act 2022 introduced a statutory sick leave scheme and provides that employees are entitled to up to 5 statutory sick leave days per year. And that kicked in from the 1st of January 2024. Sick pay is paid by the employer and must be paid at 70% of the employee's normal pay, up to a maximum of €110 per day. For an employee to benefit from the entitlement to statutory sick leave, an employee must have completed 13 weeks continuous service with the employer. An employee must also provide their employer with a medical certificate signed by a registered medical practitioner. In Ireland, some employers pay full salary for short absence due to illness or injury, subject to a remittance to the employer in respect of any state illness or disability benefit which the employee receives. If an employee falls ill during annual leave, there are circumstances where annual leave can be rescheduled so the employee doesn't lose their holiday due to illness, subject to medical certification and the statutory rules. The golden rule is to handle each leave under its specific statutory scheme, document the basis for any change, and make sure that payroll, HR, and line managers are all aligned.
Thanks, Ciara. And so in relation to the position where an employee is on sick leave, can they accrue annual leave?
Yes. So employees can accrue annual leave where they're on long-term sick leave, and this means statutory annual leave entitlements accrue during that period of certified sick leave. It's also important to note the annual leave carryover period of 15 months after a leave year will apply to those employees who could not, due to illness, take annual leave during the relevant leave year or during the normal carryover period of 6 months, and that flows from a legislative requirement. Then also important to note that on termination of employment, payment in lieu of untaken accrued annual leave will apply to leave which was untaken as a result of illness in circumstances where the employee leaves employment within that 15-month period after the end of the leave year during the statutory leave entitlement accrual.
That's great. Thanks very much, Ciara. So that's some really, what I hope is helpful guidance for employers in Ireland in relation to the many different periods of statutory leave that are available to employees. It's a really good idea to have up-to-date policies in relation to all of these different types of leave so that employees and indeed line managers are very clear on how to handle these requests, the duration and the various statutory requirements around notification. For now, thank you for listening to the Maples Group Irish Employment Law podcast. If you have any questions or queries on any of the points covered today or on any employment legal issues in general in Ireland, please do get in touch with us. Thanks for listening and subscribing.